Hi everyone. Hello, hello, hello. Welcome back. Welcome back. How's everyone doing? Good. Good. Everyone have a nice weekend? Anything fun? Any UT fans? No. A&M fans? Yeah. Okay. Cowboys fans? No, no. Texans fans? Just don't get injured. Okay. All right. With a mild, interesting property-related story. Remember last year, actually, Arian Foster wanted to sell shares in himself. He was a player for the Texans. He actually wanted people to invest in him and his productivity. And if he gets rewarded with a high contract, he would actually pay dividends on his contract. But then he got injured, and that entire thing kind of fell apart very quickly. But it's interesting. People actually try to buy shares, property rights, in a football player, which is kind of a weird idea. Anyway, small connection. All right. Well, how's everyone doing? Any questions? Anything on your mind? Anything bothering you? Anything disturbing you about contracts of sale? Yes, my friend.
I think you spoke about there's like a supplement on Westlaw that we could look at for like practice problems.
So there's a book series called Examples and Explanations.
Okay.
I'd actually recommend them for all of your classes. They're really good. There's one for property. They have them for civil procedure and torts and contracts. I used them when I was in law school. I liked them a lot. But you're welcome to use whatever you like.
Now, when I do that, I have one for property 1, but that's obviously not going to work. It has to be specific property 2.
I checked the table of contents. I think it's the same one.
Okay.
I'm pretty sure it's just check the table of contents. And actually, one of the reasons I like that series is it actually matches up with the table of contents of leading textbooks. So check how it matches up to our textbook, and I think you have most of your coverage there. What else? What else is on your mind? Yes, sir.
I forgot to check from the last class. Do you still need people to fill in the city charts?
I don't know. How about this? If I if I go around the room, you're not in the chart, I'll ask you then. You're on the chart, but I think I got everyone. Yeah, my last class, a couple people weren't in the right spot, so I had them just come after class and fill in the right seat. What else? Other questions? No? Okay, let's get started. All right, so we are slowly building our way towards actually understanding how a land transaction works. Okay? In the past couple classes, we used these terms like deeds and titles and contract of sales. And these are all various instruments and tools used to convey property. Today we want to focus in on the deed, and in particular one very important element of the deed, which is a warranty. Okay? And I think you probably all know generally what a warranty is. You've gotten them on cars, electronics, but they're basically promises to do something, right? And if for whatever reason that promise is not done, you either get something fixed or you get paid or something happens. So today we'll be talking about a number of different types of warranties. All right? So before we get started, let's restate the difference between a deed and a title. Let's start down here. Shamira, what's the difference between a deed and a title? We've done this a couple of times.
The title is the legal relationship between the person and the
Yep.
property, and the deed is the instrument, the evidence of.
Exactly. The title is the legal relationship that a person owns a piece of land. The deed is just a piece of paper. It's an instrument that contains various promises to do this or that. But the deed is only the piece of paper. It's only the instrument. Try to use the terms correctly, because often people say, oh yeah, he gave me the title, which is not exactly correct. He gave you a deed, which represents that you now have the title. Okay. The entire idea of a written title, and we discussed it before, is a factor of the statute of frauds, right? If you have any kind of land transaction in Texas or anywhere else, it must be in writing, signed by the party to be bound, right? So the buyer and seller have to sign something to indicate that there's a land transaction. Okay. I also want to distinguish the contract of sale. Okay. You remember we did in class last week the sales contract. It was this really long thing. Remember, it was like 7 or 8 pages long. There were all these different things about like asbestos and lead paint and all these other different guarantees. There's no latent defects. The warranty, I'm sorry, the deed itself is a very short document, right? Here's the one from your book. That's it, like 4 paragraphs. The entire deed is usually less than a page. Okay, it's pretty short. Now you might be asking me, oh, but what happened to the contract? What happened to all those promises that were made? Eric, do you remember the relationship of what happened to the contract and the deed? What happens to all those other terms?
Sorry, relationship.
We have that long contract. Remember, it was like 8 or 9 pages long. And we have the short deed, which is about maybe 3 or 4 paragraphs long. What's the relationship between the contract and the deed? We mentioned it briefly in class last week.
The contract secures the deed?
Close. The term we use is merger. Remember this? The contract merges into the deed. Okay? All the terms of the contract, remember, like, there's no asbestos, and you've done a fire inspection, all these other, other loaded terms, they're merged or incorporated into the deed. Okay? The reason for this is both practical and legal. The practical reason is the deed itself is what gets recorded in the county register's office. We'll do recording later. That's supposed to be nice and short. The county register doesn't want people bringing these 20-page contracts. 1 page will do it. But also, after a while, the contract itself doesn't really matter. What actually matters is the deed. So all the terms the parties agree to in the contract get merged into the deed. Okay? So when you talk about the deed, it's a fairly short document with not that much on it. Okay? Everyone okay with this? Okay. So we'll be spending most of class, or at least from the first half of class, looking at this single half page. Okay? Now up here it says general warranty deed. Okay? For your purposes, there are going to be 3 types of deeds that we're going to have to talk about. Okay? Artemio?
Yes.
Tell me, what are the 3 types of deeds that generally exist?
There's a general warranty deed.
Okay, so 1 is general warranty deed. Good.
Special warranty deed.
Okay, 2, special warranty deed. And what's the third one, Artemio?
Third one, quit claim deed.
Yes. Quit claim deed. Okay, and we're going to go through these one at a time. All right, Zoe, tell me, what's a general warranty deed? You okay? Let me come back to you?
I believe the general warranty deed, that one included the warranty of quality, and there was one other. It had 2 in there. I can't remember. I read it last night.
Okay. All right. Well, you said you were on the right track, okay? These 3 types of deeds vary based on the level of promises being given. They range. When you're buying, say you're buying a car from someone, right? Let's see. Is that Clement? Have you ever bought a used car?
Yes.
Have you ever bought a used car?
Yes.
Okay. You ever look on the window? There's usually a sticker about warranties. You ever know what that sticker says?
I would buy a used car from a used car dealer.
Oh my, who are you people? Has anyone ever actually bought an actual used car? You know what I'm talking? Yes. What does a sticker on the window usually say? Yes, okay. There's usually 2 big boxes. I'll come back to you guys later, but there's usually 2 boxes, right? One says as is, and one says warranty. And there might be a third one that says like limited warranty, right? Anyone ever see this? So generally speaking, if you buy a new car, it comes with a full warranty, right? Bumper to bumper, covers everything in the car for 60,000 miles or 5 years, whatever the warranty is. Okay. Sometimes you're buying a used car and there's going to be a limited warranty where it says we'll just cover the powertrain, like the engine. We won't cover the other stuff, and we'll only cover for say 15 or 20,000 miles, whatever it is. And then if you buy a car like I bought before that comes with no warranty, it says as is on the side, right? Everyone has some knowledge that this exists with cars. It's actually a very similar analog to the different ways you can buy a piece of property. Okay, but we're not worried about the property breaking down like a car would. Usually property doesn't fall apart, although it does kind of. What we're actually concerned about is someone else claiming a superior title of ownership, right? When I buy a piece of land, my biggest threat is not the land falling apart. My biggest threat is that someone else comes along and says, hey, that's mine. I own that land. So what the warranties do is they provide an assurance to the buyer that I promise you this land is my land. Yeah, this land is your land, right? I promise you that the land I'm selling you, I actually own and I can sell to you. And if for whatever reason I'm wrong, right? If for whatever reason I'm wrong and some other guy in the future comes along and claims that, nah, this is my land, I got your back. Or I'll pay for it. I'll either pay to defend you, right? Or in the event that it actually is someone else's property, I'll pay you a refund of what you paid me. It's the same way if you buy a brand new car with a full warranty on it, you drive it off the lot and the engine falls out within 3 seconds, you're going to get yourself a refund. He will replace the car. Or if there's something breaks that's covered by the warranty, the dealer will then cover the cost of making the repairs. So these 3 types of deeds, you know, range in the same way. So all right, is it Clement or Clement?
Clement.
Clement, tell me. Okay, so what's this general warranty deed in the context of how we just described the car warranties?
I mean, if anything was wrong with the car, it would be
Good.
what's done.
Okay, so now tell me what the general warranty deed is in property.
Warrants titling all defects in title, whether they arose before.
In your own words. Don't read.
Whether,
Don't read from the book. I have the same notes as mine.
If there's any type of, I don't know, defect in the property before or after.
Now, let's be very precise. Are we talking about like a leaky roof here? What kind of defect are we talking about?
Defect in title.
Good. What's the title? Shamir just said it a minute ago.
Titles, actual relationship.
Yes. So we're not talking about a leaky roof or a cracked foundation. What are we talking about?
Defect in title.
Okay, so what's a defect in title? What would that mean?
If title was given to someone else, fraudulently, or if it wasn't
Good.
their own, they couldn't give
Yes.
title to begin with.
Yes. A defect in title means the person selling it to you doesn't own it outright. Or perhaps there's someone else who perhaps has a mortgage on it. Or maybe there's someone who's adversely possessed it and squatted on it, right? The general warranty deed warrants title against all defects in title. And I want to stress this, that this is not the same thing as latent defects, right? That's something totally different. This is only defects in the title itself. So what are some examples? I mentioned one. Maybe the person has a mortgage on it, they didn't disclose this, right? Or maybe there's someone else who was squatting on it and has gained it through adverse possession. Right? 1 second. What we sometimes say is there a cloud over the title? Or a superior claim, right? Is there some doubt or dispute about who owns it? Okay. Shmir?
Well, I was saying, could it be when maybe someone has a license plate and they try to sell that piece of it?
Yeah. Right? I pretend, say, hey, I got fee simple. I got, you're hoping you never hear that word again, weren't you? Right? Last semester. I own this land fee simple, free and clear. I'm selling it to you as fee simple, but the dude only has a life estate. That would be a serious defect in the title. So what happens if this defect happens? The seller guarantees it, right? And we'll go into the details of this in a minute when we talk about specific warranties, but the seller backs it up. It's like, I will put my money where my mouth is. If there's this defect, I'll pay up. Okay, I want to see that in general warranty deed. Questions on this? All right, so Tim, why would anyone want anything less than a general warranty deed? Why wouldn't you always demand that this excellent guarantee on your property.
Save money.
Money. Okay? Exactly right. They're expensive. Asking for a general warranty deed, as mentioned in the book, can sometimes double the property value. This is the same way when you're buying a car, right? If you're buying a used car, if you want a full bumper-to-bumper warranty in a used car, I'm sure they'll sell it to you, but they're going to charge you a lot of money for it. So you might want to go in the cheap. You might be willing to take a risk that maybe things will be okay and pay less for it. All right? All right, so Trey, let's move on to the second one, the special warranty. Oh, any questions on general warranty before we move on? Okay, Trey, take us to the second one. What's a special warranty deed?
I think it has to do with it controls only what the seller is able to control.
Good. Okay. So a special warranty is kind of like a limited warranty in cars, right? You ever see we'll replace anything under the hood, but not other things like the brakes or whatever. Very limited. But as Trey mentioned, it only guarantees against the seller's own acts, right? It doesn't protect against the acts of others. So say, for example, the seller had put a mortgage on his land, and he didn't disclose this, right? Joseph? Joseph, yes? So say the seller puts a mortgage on his land, he doesn't disclose it. Would he now be in violation of the seller's special warranty deed?
Yes, it's not.
Okay, good. Now let me give you a different example, Joseph. What happens if the seller's predecessor, the guy who came before, put a mortgage on it? Is the seller liable now?
I believe so. It says the grant's predecessor's ownership. I guess not.
Under a special warranty deed, is a grantor liable for what came before him?
Oh, no, it's on his own house.
Yes, yes. Under the special warranty deed, the seller is only liable for stuff he does. You see there's a problem now that we've done the first two between the general warranty deed and the special warranty deed. The general warranty deed lasts basically, you are saying, I am liable for anything I do, I'm liable for anything my predecessor's done, I'm liable for any defect that came around 100 years ago. Even if I don't have any knowledge about it, I'm still on the hook for it. The special warranty deed says, you know what? I'm not quite sure what happened before I got here, so I'm going to limit myself. I'm going to limit my liability to what I did personally. If there's some defect that arose 100 years ago, buddy, you're on your own. Everyone see that? These are cheaper than the special warranty deed. And it makes sense because you're not covering possible flaws that stretch back 100 years. You're only covering flaws that you yourself incurred. Okay, everyone see that? Okay, Angela? Tell me, what is the last one, the quick claim deed? What's this? Yes, yes, exactly right. It's as is. There are no warranties whatsoever. With a quick claim deed, I'm selling it to you literally as is. I make no promises about whether I have good title. I make no assurances whether anyone has any clout over anyone has a superior claim. You're taking it as is. As you can imagine, these are the absolute cheapest of the three because the seller is not on the hook for anything. Okay? The seller will not be on the hook for anything. Okay? Now, Garrett, what do you think a buyer can do to protect himself if there's a quick claim deed being offered?
What can a buyer do to protect himself?
Yeah.
Considering buying?
Yes, sir.
You could maybe have a title company do some research.
Good. Okay, and we'll do this later in the semester. But this isn't the end of the road, right? if someone offers you a quick claim deed and says, I don't make any assurances, you can do your own homework. You can do a title search. You can hire a title company, and they can tell you, is this title good? It's funny. A lot of these warranties aren't nearly as valuable today as they were years ago. Today we have a very advanced title search process. A lot of it's electronic. Back in the day, you really didn't know who owned something until some guy came back from the crusade and said, hey, that's my land. I'm not really exaggerating too much. There were a lot of cases where people went away to fight for years. Someone thought they owned a piece of land, and then someone else comes back and says, no, that's my land. At that point, the only thing you can do is go back, whip out your general warranty deed, and say, hey, defend me, pay me back, compensate me. Because there wasn't really an effective way to do title searches. That's fairly modern in the property scheme. Okay. The hand?
No, I just scratched it. Thank you.
Okay. Questions on this? Right, so remember, yes, sir.
So you can't, the buyer couldn't protect himself by, or maybe you can't, by contract, putting conditions into the contract, if X happens, you're liable.
Well, that becomes like a special warranty deed, doesn't it?
Right, merges into the deed, so.
Right, I mean, but at that point, you're not doing quick claim. You're actually asking the seller to agree to certain conditions.
But then if he issues a quick claim deed, doesn't that supply?
It won't be a quick claim if there are any conditions on it.
So is there ever a quick claim deed?
All the time, yeah.
I mean, so there's requirements by law that you have to have this.
Ah, well, I think you're confusing two things. Does a contract refer to property itself or defect in the title? Ah. That long sales contract, which we did last week, was all about defects in the property. Is there asbestos? Is there lead paint? Is there any latent defects, right? Or all these things. That's separate and different from whether you have good title. Right? The only phrase in the entire contract that actually reflects this is, remember, good and marketable title? But even then, maybe the guy's lying. Right? Maybe the seller is a jerk. He's lying about it. So the way you protect yourself is actually with what type of deed you get. And quick claims are very common. Say someone's in a hurry, they don't really have time to research it, they just quick claim it, buy it on a cheap. Hope it works out. If it doesn't, then you know, they'll figure it out later. Anyone ever involved with a land transaction using quick claim deeds? Want to tell us about it?
I mean, yeah, I just, you know, in quick claims, they're conveying any interest, if they have any at all, to, you know, whatever, I guess, like the company that's buying
yeah.
Whatever. So it's kind of sketch.
Yeah, it is.
You don't really know if you have
Sketchy.
Sketchy.
Yes, is the adjective.
I don't know. I kind of just glossed over the rest of it.
Yeah, the Y just dropped off. Yeah.
How do you like come up with how much more is it going to cost? Like, what figures you use? Like, this is how much would be the general.
I don't know what the market rates are, but I'm sure real estate dealers know the differences.
It's like a formula they're using.
If I had to guess, based on the value of the property and how much exposure there is, they calculate how much additional insurance is worth. Yeah. You can also buy something called title insurance, which we'll do in a couple weeks. That means if you buy a piece of property and you're not sure what the deal is, you can actually, and the seller won't give you any insurance, you can buy insurance from a title company. And if it turns out the title is no good, the title company will pay you back. So there are lots of ways for buyers to protect themselves. All right, other questions? Is that a hand or an elbow? Elbow, I guess. What else? Okay. So let's go back to this. It's on page 586. Okay, and we see from the very top, and we'll go through this pretty systematically. We'll be on this for a while. So you see from the very top, we have here a general warranty deed. So we know this is our gold standard, right? This is the A+ deed that we all love. Okay. So it says, I, John Doe, grant to Nancy Rowe and her heirs, blah, 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 for $10 under consideration, the following real estate, blah, blah, blah. Okay, so again, we have to describe the real estate with some detail. Okay. We have here this language, to have and to hold. If you read the footnote, which I always encourage you to do for fun, this is a phrase that's been in deeds for like 1,000 years. This phrase, to have and to hold,
which doesn't really even make too much sense because it's kind of redundant. What's the difference between having and holding? But what's interesting is the reason why lawyers repeat the same words over and over again is because they're afraid they might omit something that a court will demand, right? So I'm sure at some point, some court in England said, you need this phrase to have in your deed. Okay. And then some other court said, oh, no, you need this phrase to hold in your deed. So if you're a smart lawyer in the 1600s, you say, you know what? I'm going to cover my bases. I'm going to make sure I don't get in trouble. So I'll put both of them. I'll do to have and to hold. And this is why law sucks, right? This is why we have such redundancies and repetitive clauses over and over again, right? And are heirs and assigns forever. I mean, it's repetitive. But you have to include them because no lawyer wants to be the guy that says, you know what? This is repetitive. I'll cut it out. I'll omit it. Because once you do that, you've now put yourself client at risk of losing. So the reason why we have to deal with all of these repetitive synonyms is because of conscientious lawyers hundreds of years ago trying to make sure their clients don't get screwed. Okay? All right, so we have this phrase, to have and to hold the premises with all the privileges and appurtenances belonging thereunto, to the use of the grantee and her heirs assigned forever. Okay. Now we come to the warranties, right? This is the fun part. You'll see here that there are 6 covenants listed. Okay? There are 6 covenants listed. More specifically, the first 3 are what we call present covenants, and the second 3 are called future covenants. Let's go through these one at a time. Okay? The very first one, it says that the grantor is lawfully seized in fee simple of the premises. Okay. Hugo, where have we seen this word seized? What does this remind you of? Good. What's that thing they do in the woods with the clump of dirt? Remember that? What's it called? Seizing, yes. Okay. So, ever remember this from Property 1? That before there were written instruments, the way you signify transfer of property is that you go to the dirt, you take a clump of dirt, you put it in the person's hand, you twiggle it, right, with a little twig. That was called livery of seizing, right? You saw the video, right? You didn't see the video of the livery of seizing? All right, I'll play a few. What? No.
Someone to remember, like
Yeah.
So they
To commemorate it, they bring a kid and they slap him.
Here, I'll show this to you because it's they're.
Today we're talking with Michael Robinson from Robinson & Henry Law Practitioners. Michael, welcome to the show. Thanks for being with us.
Glad to be here.
We had you on a previous segment, and we were talking about deeds and the different types of deeds. We went through the standards 6, but at the end we started talking about a very which they use transfer property, and it was called livery of season. Is that correct?
Sure is, and that's where the word deed actually comes from, is that action.
All right, real quick, what is livery of season recap?
Okay, because most people were illiterate in England at the time this thing developed, they would bring witnesses out to the property, and witnesses would be able to witness the buyer giving money, the seller giving over the actual physical parts of the property, namely turf and twig, which is the two things that it's called turf and twig ceremony.
All right, so for a first time ever on Broker IP TV, we'll do a reenactment here.
I think it's an excellent idea.
So what we're going to do is we're in Old England, and we're going to transfer property. And of course, we have to dress the part.
You always need to
Now, am I the buyer or the seller?
You are the buyer.
And you're selling me this land.
Yes, and we've come out here with 2 witnesses
Okay.
to watch
All right.
all this happening.
And how does this procedure go?
Okay. You're going to start by cutting out a piece of turf on the property.
All right. So we'll just.
And you hold on to that turf.
I hold on that turf. Okay.
Now, put money in the hole.
All right. I got some cash. How about a buck for this?
Buck
Will this
works
work?
here. It's a couple shillings back in Old England.
Okay.
Okay. And then hand me the sod.
This piece?
Yes, you do.
Okay.
And I take the twig.
Yes.
And I take the sod, and I say this following: This twig I give to thee, as free as Athelstan gave to me, and I hope a loving brother that will be. And I twiggle you with the twig.
Twiggle.
Really?
Yes, I do. And then I put it in the sod,
He's
and I
getting twiggy
hand
with
it
it.
to you.
Thank you.
And then you take the sod and put it back in the hole.
All right.
And with that, you just bought this wonderful property.
And I've been twiggled.
Yes, you have.
Okay. You'll never forget that again for the rest of your lives. You'll forget everything else I tell you, but you remember twiggling. Okay. So you've had this phrase, livery of sizen, right? The word seeds and size refers to some sort of ownership. Okay. So the first covenant that we have to talk about is what's called the covenant of sizen, or season. I've heard it pronounced both ways. I don't know which was the right way, but I say sizen. This covenant suggests that the person owns the estate that he's conveying. The covenant of sizen means that I own the estate that I'm conveying. Literally, it means at some point someone twiggled me, right? It literally means at some point someone did the twig and turf and put the dirt into my hand, and I have sizen. I have this sizen, right? So if you go back to the deed, it says number 1. Everyone can see this big enough? Okay. That the grantor is lawfully seized in fee simple of the premise, which means, you all know from last semester, that the person was twiggled with fee simple. I own it, and I can transfer it. Okay? Okay, so now welcome to redundancies. Okay? The next one is basically the exact same thing. Okay? Not exactly, but close enough. It says, number 2, that he has a good right to convey fee simple. Okay? This is what's often called, I'll go to number 2, the covenant of the right to convey, which means that you have the right to convey the property. This one's self-explanatory. Now you might ask, Josh, what's the difference, right? If I own something, why can't I sell it? Yeah?
Because partially owned by someone else.
But do you own a fee simple then?
Oh, no.
Ah,
How would adversely possess it?
maybe.
In the example they give is a trust, that the trust can only do with the property.
Good, good, good.
Should we make some of it like encumbrance on land? Only supposed to be used for this.
Ah.
Or this amount of time.
Okay, good. You remember your bundle of sticks from last semester? I taught this an hour ago in this exact same spot. Deja vu, right? Remember you have the right to use, the right to exclude, the right to sell. You may have the right to use land, but you may not have the right to sell it. Examples given are correct. Maybe there's someone squatting on it, right? Maybe there's someone that has a trust over it where you can use it but you can't sell it. Maybe there's some sort of a condition. Remember the fee simple subject condition subsequent that you were tortured with last semester. There might be a condition that says you can't sell it. For all intents and purposes, one or two are the same thing, but there is a subtle difference. Okay. Okay, let's go to number 3. Okay. Again, it's also somewhat redundant, but as we said, lawyers like covering their bases, and they give you 3 things that more or less mean the same thing. There are no encumbrances, right? The premises are free from encumbrance. Okay, what's an encumbrance? Okay, so this is what's called the covenant against encumbrances. Okay, what's an encumbrance? Mortgage, lien, An easement or a covenant, we'll study those later. Okay. There's no restrictions on the land. All right. Everyone with me so far? All three of them basically mean the exact same thing, right? All of them basically mean, is it a good title? I mean, it's almost entirely redundant. They're all asking the same question. Is it a good title? Right? One thing I like to draw attention to. I want you to pay very close attention to the tenses. Okay? I heard a really bad joke. Let's see how much you've grown. Past, present, and future walk into a bar. It was tense. There it is. Not enough of you laughed. Everyone get that? Good. Look at the tenses on this. The grantor is lawfully seized, right? He has a good right. The premises are free. What tense is this? Present tense. Okay, so these are what are called the present covenants. And you know this because all the verbs are in the present tense, so this is actually very easy. Even if you forget everything I just told you, if you look at the grammar, you'll know if it's a present covenant or a future covenant. It's all in the present tense. Hopefully you remember your grammar. Maybe not. Why is this relevant? Okay. The key to the present covenants is they can only be broken at the time of the conveyance. Present covenants can only be broken at the time of conveyance plus a statute of limitations. What was a statute of limitations? Ever remember SOL, statute of limitations? S out of luck, right? Okay, good. The present covenants could only be broken at the time of the conveyance. And this makes sense. If I don't have sizen when I sell it, it doesn't really matter if I get sizen later. If there is an encumbrance upon the property at the time of the sale, it doesn't really matter if it goes away. What matters is when I bought a piece of land, these defects were there, and I'm allowed to sue on them. Now, just to make one point clear, you're not required to sue immediately. You're not. You have a statute of limitations, which could be 2 years, 5 years, 10 years, whatever the jurisdiction is going to be. The reason why is you're not expected to find about these things instantly. You find out about them when they happen. Right? You have some reasonable time to do diligence and find out. Okay? The difficulty, though, of the present covenants is they can only be sued on within a couple years of the purchase. What we'll find in the case we do later is that someone waited too long to sue and they were out of luck. Literally, S out of luck, SOL. Everyone okay in the present covenants? Okay, let's turn to then the next three. These are called the future covenants. Okay? And how do you know it's a future covenant? Language. The tenses change. So let's look at the first one, 4. Okay, 4 says, the grantor and his heirs and assigns will forever warrant and defend the grantee and his heirs and assigns against every person lawfully claiming the premises. Your key word here is will forever warrant and defend. Even if you remember nothing I just told you, the verbs in the future tense, this means it will go on forever. This warranty stays on, like Celine said, on and on, right? Forever. There it is. Titanic was 15 years ago, is that right? Yeah, it's been a while. So what's actually being promises? Not only the grantor, but the grantor's heirs. So even if the person who sells it to you dies, the person that inherits it is now bound by this covenant. And what are you protected against? Anyone at any point who claims the premise. So if someone comes along and says, hey, that's mine, this deed will defend against that. It doesn't matter if it happens in 10 years, in 20 years, in 50 years, or 100 years. This will be basically a promise forever. This one is this one's called number 4, the covenant of general warranty. Okay? The covenant of general warranty. So basically, the defendant and his heirs will defend against lawful claims and compensate the buyer for any loss. Okay. The covenant of general warranty protects against other people making claims. Yes, sir.
The defendant and his heirs, the grantor and his heirs, do the heirs actually have to defend the title?
Yes.
What if you're a child?
Doesn't
You
matter.
don't know anything about
When you oh, actually you do. How did you get the property?
Well, I'm asking. Does the
How do you if you're an heir, how do you get property? And what happens when you inherit? What strings come attached? When you inherit property, you take with all the strings. So say if there was a fee simple subject condition subsequent on your father's land and you inherit it, does that go away? You're bound by the sins of your father. You could decline the land, you don't have to take it, but if you take it with the same strings.
But I'm talking about the seller's son.
Doesn't matter. Your father made a condition, right? And you now have inherited that future interest. It's effectively a future interest, a negative future interest, but it's a future interest, and you're now bound by it. So be very careful if you're pushing general warranties. You're binding your children. It's true. Properties goes on and on forever. So say Garrett sells a piece of property for the general warranty in year 2015, and then you're in 50 years your child is now the inheritor of that general warranty deed, and a problem arises. Your child will now be required to compensate. Right?
Could the child sue the father's estate?
Well, presumably any money would come from the father's estate, and if there's none left over, the kid's on the hook. So be careful choosing your kids, right? You don't want to bind them too hard. So the covenant against general warranties deeds goes on forever, but when does it kick in? Right? I'm up to Stephanie. When does this covenant of general warranty kick in? What has to happen to trigger this warranty? Let's walk this through. What has to happen for there to be a legal claim of your property by someone else? What has to happen?
Somebody has to try to say that you don't have title.
Yes. Someone else needs to come in and say, hey, that's mine. Exactly right. So there's a big difference. The covenant of season occurs at the time of the transaction. Either I own it or I don't. The covenant of general warranty only kicks in if someone makes a claim to the land. Everyone see that? Say say Garrett's son owns a piece of property, and he finds out that someone else has a superior claim to it in 50 years. Rebecca, is that enough? If you just find out that someone else might have a superior claim 50 years later, is that enough to trigger this warranty?
They're defending against the third party.
Has a third party has not made a claim yet. No one's made a claim. You just discover that there's some outstanding claim of your land.
I'm not understanding.
In 50 years, Garrett's son finds out that the title wasn't good. Someone else has a competing claim. That person hasn't done anything on it. Is that enough to trigger this warranty?
No.
How come?
Future act, somebody has to do.
There must be an act. Exactly. There has to be an act. The rub of the future warranties is someone has to physically come in and try to either eject you or file a claim to take over the property. If that doesn't happen, you can't rely on the future covenants. And one more point, the statute of limitation starts running when the claim is made. Statute of limitation runs when the claim is made. So say some other guy, some third party comes in and files an action to eject you from your land, right? That's when your clock starts running, and then you can go and sue on the covenant of general warranty and get money from Garrett's poor son. Shamir?
50 years after the person's been there, so I'm still stuck on the adverse possession. Like, wouldn't it?
Well, let me ask you this question. If you're on a piece of land that you think you own, are you there hostile? Ooh. Ah. So if you're on a piece of land and you're not even aware that you're squatting, depending on the jurisdiction, you may not have any luck. Now, the more modern trend we've discussed is it can be an accident, right? Remember the staircase that went over the couple inches? They didn't even know they were squatting. But under the common law, it would have been enough. You have to be actually hostilely there. But that requirement's been dropped in recent years. Yes, sir.
We're just buying up the Paramount claim. So if it's claims out there and you buy it, then it's in as well.
Well, what happens if, say, in 50 years, you find out that there's a claim against Garrett's, the son's house, you buy the claim from the person, and then you try to enter and eject them. That would then trigger this. In other words, if someone has the key word here is lawful, right? If someone brings a lawful claim, that's what starts the clock and triggers the warranty.
But if you proactively go out there and buy it, then it doesn't start the statute.
Well, if you buy the claim from someone who has it lawfully, then yes, they'll do it. Other questions?
Someone else, like a third person?
It doesn't matter who it is. If someone has a lawful claim, that triggers it. Okay. The number 5, the grantor and his heirs will guarantee the quiet enjoyment of the premise. Again, will is a future, right? Number 5 is what's called the covenant of quiet enjoyment, which again is the same thing as number 4. There's not much of a difference here. Quiet enjoyment doesn't mean like shh, you gotta no noise, right? Quiet enjoyment refers that no one disturbs you in possession, right? Okay. Specifically, no one with a superior title will disturb you. Right? This is the same thing as number 4. It simply means that no one with a superior title will come and try and kick you out. Okay, yes, sir.
So on number 5, following on Garrett's question, you take out the word and its heirs and assigns. Would that limit the?
You can't do that.
No.
No, and I mean this sincerely. These are phrases. The way these are phrased have been phrased like that for hundreds of years. These are the things that courts recognize. So once you start taking those out, you don't have a general warranty deed anymore. Now you have a special limited warranty, right? Remember there were 3 kinds. Once you make it that doesn't apply to future whatever, you're now limiting it to the special warranty deed, right? Okay, other questions? Yeah, 4 and 5 are. There's not much of a difference between the two of them. And 6 says the grantor and his heirs will on demand execute any instruments necessary for the further assurance of the title. This is just a requirement that if you need to sign some stuff in the future, you'll do it and you won't be unreasonably like a jerk. This one's not too important. But it's referred to as the covenant of further assurance. And the grantor will execute any documents. This one's not too important. Yep. The most important thing for you to remember from these ones are present and future. The first 3 are the present covenants. These can only be sued on at the time of the sale, plus some statute of limitations. This is whether the seller actually has title at the outset. The second set, these future covenants, these only kick in when someone asserts a superior claim to the land. These only kick in when someone moves to eject you or something. And then the clock starts ticking. So these can be lurking in the background for years, but someone has to physically take action to kick you out. Okay, questions? Yes, sir.
If the second, three, like 4 through 6 are forever, why is there a statute of limitation?
Let me be very precise. The warranties are there for the life of the property, so basically forever. But once someone moves to eject you, you have to have only a certain period with which to sue on the covenant.
So that's the amount of time you have to do.
Exactly. The statute of limitations is once someone moves to eject you, you can't get ejected and 30 years later sue the original grantor. You have to actually sue on it within a certain number of years. Other questions? Okay. I have here a couple samples. I pulled these up from I don't even know where, but just these are a general warranty deed from Brazoria. Let's see, we're gonna buy the covenants. Here. So here's this language again, right? It says to have and to hold the property. This is this phrase which is in every single deed you'll probably ever see in your lives. And slightly different, but blah, blah. Grantor does hereby bind itself to its successor in science to warrant the purpose of defend against blah, blah. Yeah, basically, it's the same deal. Forever and ever, we will defend you against any superior claim. The language is phrased somewhat differently, but if it's a general warranty deed, it has to be on forever and ever. You're not going to be responsible for writing these. I wouldn't ask you to do this, but if I ask you something with similar language, you should be able to figure out roughly which covenant we're talking about. If you say it's number 4 or number 5, I don't really care. They're probably the same thing or close to it. But you need to distinguish between the present and the future covenants. That's the most important element, because that's where we get burned if you don't bring it quickly enough. Questions? Okay. All right, let's do the first case. Brown v. Lober, please. Let's see what we're up to. Okay, right there. So that's Stephanie? Okay, tell me, what happened in Brown v. Lober, please?
So the Browns wanted to sell their mineral rights, but they found out they only owned 30%.
Okay, remember, you sell separately your surface rights and mineral rights. You can be living above ground, and you can sell your mineral rights separately, and even you can sell a fraction. So you say, I keep a third, you get the other 2/3. You can split the profits. All right, Stephanie, sorry to interrupt. Go ahead.
So, and we tried to see on it, but there's statute.
Good. Okay, so what happened?
So the trial court said that it's going to be because of the statute of limitations. They're trying to say that they're constructively.
Okay, good. So we have here is a situation, right, where there was a defect in the title, right? What was the defect in the title? The defect in the title was that someone had reserved mineral rights for somebody else. In other words, they did not own it in fee simple. Okay? This is a problem. If you're pretending to sell a piece of land in fee simple and you don't own it in fee simple, you are actually violating your title, right? You're giving a not good title. So, is that Brooke? So, Brooke, of the 6 covenants, which one or ones does this act violate? Because at the time of the sale, you don't actually own it because these mineral rights are reserved to someone else. That's exactly right. So the correct way of actually litigating this case, right, would have been to bring a violation of the covenant of Sison. You said, at the time you sold it to me, you did not have fee simple to these mineral rights. Therefore, you don't actually own what you're conveying. Pay up. Okay. So, Lamar, why didn't they bring a suit under the covenant of Sison in this case?
I'm not sure.
What covenant did they sue on?
Under the quiet enjoyment.
Is quiet enjoyment a present or a future covenant?
Future.
Okay. So why do you think, and if you look at the dates, it might help you a little bit, why do you think they relied on the quiet enjoyment covenant and not the covenant of Sison?
I mean, my guess because they didn't know. They didn't do a title check.
When was it? What year was the property acquired? Yeah, 1947 or so, right? 1947, 1956. What year was the lawsuit brought?
74.
20 years later, right? Yeah. What's the problem here? What do you think happened? They burned their statute of limitations, their SOL. They were SOL in this case, right? If there's a problem with Sison, in other words, someone said, I'm selling this to you fee simple, but they actually only owned a fraction of it, the time to bring that suit on the covenant of Sison will be at the time of the sale or within some statute of limitations afterwards, whether 2 years, 5 years, whatever it is in that state. They didn't do that. They waited 20-something years to bring suit. So after 20 years, these first 3 options were all burned. They couldn't bring it, right? So Heath, what were they stuck with? Yes, they were stuck with their future covenants, right? And the reason why they were stuck with them was those can be brought at any time. Okay? But, Daniel? But there's a problem in this case with the suit of quiet enjoyment. What needs to happen to file a suit against the seller under the covenant of quiet enjoyment? What needs to happen first? Yes. Someone needs to make a superior claim. Did that happen in this case? Good. So what happened in this case was they found out that they didn't own the entire land, that someone had a fractional interest. Did anyone else assert the superior claim over them? Exactly. In order to trigger the quiet enjoyment covenant, some third party needs to come in and dispute, saying, hey, you know what? Those are my minerals. Those are mine. Had that happened, they could have sued under this covenant and gotten money back from their original grantor. Yes, sir?
But if they try to extract the mineral somehow, and then that company who owned it came and sued them,
Ah.
then that would work, right?
Yes, so they jumped the gun here. The problem in this case was they jumped the gun. They went to court too early. They actually went to court too early. What they should have done was either start drilling themselves, right, or wait for some other company to come in and assert the superior title to the land. But Daniel, what's the problem though with drilling on something you don't actually own? What could have happened if they did that?
It's a trespass.
Yes, they're inviting a trespass lawsuit, right? If they're drilling on a part of land they don't own, they're inviting a lawsuit. So they're literally between a rock and a hard place, right? What were their options here, right? Lee, what were their options here? What could they have done? What were their options here?
Well, maybe what you say, 79. Yeah, I mean that's not too terribly long ago. Before buying the property, do their homework a little more.
Yes. So they could have done the homework at the outset, but we know they didn't. They were lazy, right? They didn't do their homework. What could they do now in the 1970s? Or how could they have fixed the situation? Think about it.
Couldn't they have sued the people who own the land for possibly misrepresentation or something?
What was the statute of limitations on that kind of thing? Probably a long time ago. See, what you're getting at is you want to sue on one of the present covenants that they actually added, but they burned that statute of limitations a long time ago. So they're in a weird spot, right? They can't sue on the present covenants because they burned the statute of limitations. They can't sue on the future covenants because no one's bothered them or tried to kick them out. What the heck can they do? Anyone? Yeah.
Buy the mineral right?
Yeah. They could have offered to buy out the other third remaining share. So that they would not have committed a trespass. But they didn't want to do that. They just wanted to cash out. So this was a rough case for the for the plaintiffs because, frankly, they didn't do their homework, like Lee said. If they had done their homework when they first bought it, they would have been aware that someone else had a reserve right to the minerals. Yeah? And I think the court gets it exactly right here. What the court says is they're trying to turn a future covenant into a present covenant, right? They're trying to fit the covenant of Seizen into the covenant of quine enjoyment. And the court rejected their efforts to do this for a very important reason. They said, you have to wait till someone actually asserts a superior claim. If no one asserts a superior claim, nothing's happened yet, right? Literally. No one disturbed you. No one disturbed your quiet possession. It says, in the opinion, the mere existence of paramount title does not constitute a breach of the covenant. Just because there is a defect in the title doesn't mean there's a breach. That's the opposite of the covenant of Seizen. If there is some sort of paramount title, the covenant of Seizen has been violated. But that expired many years ago. The court said, even if there was superior title, there was no pressure upon him. Okay? Everyone see that? All right, questions on that case? The most important thing is, for a future covenant, someone needs to disturb your possession. Someone needs to physically come in and assert a superior claim. Until they do that, you can't sue on it. Everyone, am I okay with that? Do the next case? Yeah? Okay, Brittany? Brittany, what happened in the Frimberger versus Anzellotti case, please?
The defendant received some property from predecessor D. Loretto, and we're building a bulkhead adjacent to this wetland.
Okay, by the way, everyone know what a wetland is, right? Swamp. Right. Wetland is a fancy word for a swamp, and they're often protected. And the trick is, if you do any work on a wetland, you need the state's permission. Okay? And as Brittany said, Anzellotti's brother basically filled a wetland. Everyone knows what that means? You basically dump concrete and other, dirt and other rocks into a piece of wetland to make it solid. And once you make it solid, you can build upon it. You can't build on a wetland because it's wet. So if you want to build on that land, you need to actually fill it in. You might not know this, but much of Washington, D.C., our nation's capital, was originally a swamp. And almost the entire thing was filled in with dirt and crap and other stuff to make a city. New York City, if anyone's ever been to Manhattan. The reason why lower Manhattan flooded so much after Hurricane Sandy is that's below sea level, right? Why is it below sea level? Because much of lower Manhattan was filled in with dirt and other garbage. Right, literally, most of Manhattan in the bottom was not there 300 years ago. They actually expanded the land. Even Ellis Island, where all the immigrants came through, that was actually created by dumping dirt into the ocean and actually making an island. Okay. So what the guy did here was a no-no. He filled in wetlands without permission of the state Environmental Protection Agency. Okay. Sorry, Brittany, I didn't mean to interrupt. But proceed, please.
Then the defendant gave the land, made the property for plaintiff, but I was going to see him to free of all encumbrances, if anything,
okay, very good. All right. So the defendant's brother filled the wetlands in with the cement and with other stuff, right? Then here, the defendant transferred to someone with a general warranty deed. Okay? And he said in the deed that it was free and clear of all encumbrances, but it was subject to building and zoning restrictions, right? Is that Jane? Jane, encumbrances. We defined that word before. What are encumbrances? We gave some examples of encumbrances. You remember what those are?
Mortgages.
Good. Generally speaking, historically at least, encumbrances were mortgages or liens, or maybe an easement or covenant restricting the use of the land. But the general warranty also speaks to building and zoning restrictions. Right? So we did a case maybe a week or two ago involving the house. Remember, it had to be a certain number of inches from the sidewalk right? And the court there held that the mere act of having some sort of a zoning ordinance didn't render the title marketable, but the fact that you were selling something that violated the ordinance was a no-no, right? So here we have this environmental statute, right? And Sumaya, was this property in violation of this environmental statute? Okay. Had the government taken any action to enforce that? No. Okay, and that's the key. What's interesting here is that the government had sent different letters saying, hey, guys, we discovered that you are in violation of the wetland. We need you to do this survey and write this letter and whatever. But they hadn't taken action yet. Okay? The second the government said, hey, you have a problem, the homeowner said, uh-oh, I'm in trouble. Let me go sue someone. Right? Has anyone ever had an experience with the State Environmental Protection Agency? Okay, generally, I'll put this nicely. If they found that you filled a wetland, you're in trouble. You are in big trouble. You are going to be responsible for fixing it and paying a lot of money in fines. And the way environmental crimes work is that even if you didn't do it, but it's on your land that you own, you are responsible. So say if your predecessor dumps some waste in your backyard and only becomes known decades later, it's your land, you're on the hook. Okay? So even though the state hadn't brought any enforcement action yet, stuff was about to get really bad real soon. So they quickly brought suit, and they sued on the general warranty deed. Okay? So Tyler? Yeah. All right. So what happened after they brought suit on the trial warranty deed, on the general warranty deed?
At trial court?
Yeah. Go. We'll just walk through it. Yeah.
Yeah. So at the trial court, they found that it was a breach of warranty against encumbrances, and that it was an innocent misrepresentation, and they awarded damages of almost $50,000.
Okay. Good. So the trial court said, hey, listen, there's this statute. When you sold it, you violated this covenant against covenants and warranties. The same thing. So covenants against encumbrances, we'll give you damages, right? All right. I guess so. Joseph, what did then the Court of Appeals do on appeal?
They said that it was not an encumbrance
because
it's different from the other types of encumbrances that we typically think of.
Why? Okay. Good. Why is having a violation of this environmental ordinance not an encumbrance?
They said it's basically like a latent encumbrance that would be kind of hard to find out about in a title search. And so it would make it okay for people to try and warrant in the future that there's no, that the land's not violating the statute because it's sometimes hard.
Okay. So what the court does here is they depart from the common law. And this is maybe called an environmental exception to the law, right? We did in the case of Lohmeyer v. Brown. This was that Kansas case where, remember, the house had to be a certain number of inches from the street, right? And the house was too close to the street. The court there held that the violation of the ordinance was an encumbrance on the title. You didn't even know what that word meant when we used it yet, but now you do. In that case, the Lohmeyer case, the violation of the ordinance was an encumbrance on the title. Okay? Here, the court holds the exact opposite. The violation of this environmental law is not an encumbrance on the title. Right? Therefore, because it's not an encumbrance on the title, there's nothing to sue on this warranty. Okay? Everyone get that? This is the exact opposite of the holding from the Kansas case. And the book attempts to reconcile them. I think it's a difference between Kansas and Connecticut, but you can do it however you like. But this trend is effectively to say that merely violating an environmental law doesn't constitute encumbrance. Okay? But, Stephen, what would have happened if the state agency had brought some sort of enforcement action.
Then there would be a violation, and then there would be grounds to bring a cause of action.
Why? What does the law? What does an enforcement action from the state constitute? What would that mean?
It would be contesting the warranty or the title.
Effectively, yes. Right. One of the clouds that can be over your piece of property is litigation. Right. So if the state threatens a lawsuit against you that can fine you a lot of money, you are now within either one or two. I'm not really even sure which one. Maybe all three of them, right? Because you're limited. Your property's now been limited. What the court says, in my mind, somewhat implausibly, is that these letters from the state aren't enough of a threat, right? That someone has to the government has to actually file a lawsuit against you. And I'm going to disagree with that. You're smirking. Why are you smirking?
Oh, they're obviously going to.
Of course they're going to.
Once they set their sights on you, they're not.
Yes. So if anyone's ever dealt with any government agency, right? When they send you a letter saying, "Hey, we'd like more information," you're screwed, right? Like when the IRS sends you a letter saying, "Hey, we'd like to see all of your records in the past 5 years," you're probably in trouble. You're probably headed for an audit. I mean, they don't send letters out of for correspondence and sake just to see how you're doing, right? So the court effectively says, unless you've been hit with a fine or there's a lawsuit hanging on your head, you're in trouble. Now, recall there's a statute of limitation on this, right? Governments don't always move quickly. They often come much later. So what if they don't bring the suit against you for 5 years, right? At that point, you've now burned your statute of limitations. 5 years have come from the sale date. So if I'm guessing the reason why this lawsuit was brought was they were afraid that this could drag on for years, at least bring the other guy into it. All right, everyone see that? It's kind of a weird holding, but it puts a serious burden on subsequent buyers. But this is the general trend for environmental laws. We don't do a lot of environmental law in this class. I encourage you to take another course in it. But if there's any damage on your land to the environment and you didn't do it, you're still on the hook. There's no way around it under most environmental law. All right. Questions? Any other questions? Let's see. We have one more case. Okay. So one interesting aspect about deeds. Okay. Are we done with the covenants? We can move on from that? Okay. So one interesting aspect about deeds is that you have to actually have delivery. And delivery doesn't just mean you hand someone a piece of paper. You need to intend for the deed to become effective immediately. And the reason this is important is because of something called the statute of wills. Let's see. Blaine, do you know what the statute of wills is? Mention in the reading. Anyone, statute of wills. Yeah.
That the disposition is valid of your land or whatever.
Yeah, you're on the right track. When you want to give some piece of whatever, land, property, and it goes into effect after you die, you're not under the statute of frauds, right? If I want to give you a piece of property today, we satisfy the statute of frauds. If I want the property to become transferred after I die, we use something else called the statute of wills. You'll take a class in trust and estates. I'm not going to bore you with all those details. But for our purposes, with the statute of wills, you actually need 2 witnesses to sign it, right? Generally, with the statute of frauds, you only need the parties to be bound to have to sign it. With the statute of wills, 2 witnesses need to sign it. It's very difficult. You have to have a lot of formalities to go through the statute of wills, right? Why does this matter? If I want to give someone property after I die, and I don't follow the statute of wills, it's void. It's as if I died without a will at all. Okay? So what happened in this case is that the old the aunt and the uncle try to get around the statute of wills. All right, so Blaine, what happened in the was it the Rosen case?
So basically, this older couple, were didn't have any children, but they're I guess really
A little bit louder, please.
sure. This older couple didn't have any direct children.
Right.
So there's one of their nieces, nephews, and their spouse were kind of helping them out.
Right.
So they made a commitment to give them their farm, and so they all went to the bank.
Okay, so stop for a second. So, yeah, so you have this old couple, aunt and uncle, right? And they're getting quite ill. One of their nephews is being a good Samaritan, and he's helping them out. He's taking care of them, taking them to the doctors, whatever, right? And the old couple says, you know what? Thank you so much for taking such good care of us. We want to reward you. So we want you to have this house after we die, right? David, why didn't they just give them the house right away? Why didn't they just say, here, have the house right now?
Because they wanted to continue living in it.
Right. Okay. So they wanted to continue living in the house. So they didn't want to give him the house right away. David, what else could they have done short of giving him this thing after they died? Think back to property one. What could have been a really easy way of doing this?
You know what the executive interest?
No? What could someone mention it before? What could they have done? Anyone else?
Keep themselves in technical interest.
No, you said life estate. Life estate. So the easy way of doing this would be to say, husband and wife retain a joint life estate, and then when the last one of them dies, it goes to the nephew. Piece of cake, right? That'd be easy. But they didn't do that for whatever reason. Maybe they didn't really trust the they didn't trust the nephew. Maybe he would duck out at the last minute. They could rip up the deed. Okay. So they also didn't want to sign a will, right? This is not in the case, but if I had to assume, wills get contested in court, right? Wills get contested in probate. They probably didn't want to go through that. So they hatched up this idea of how they can give the property to the nephew after they both die. Claire, what was this cockamamie plan they hatched up?
So they had met with their banker.
Uh-huh.
They had put the deed in this envelope.
Yeah.
It was scored. It had both their names on it.
Uh-huh. All right. Yeah. So basically they had this idea, right, where the uncle writes out the deed. He literally hands it to the nephew. Okay, the nephew has it. Then the nephew hands it back to this banker guy, and the banker will keep it in a signed envelope that can be retrieved at any time by either of them, right? Both their names on it, either can retrieve it. And presumably, the idea was when the uncle dies, the son will go to the bank, take the deed, and now the thing will be his. Okay. So that's Michelle. So before we get to the holding, after they did this entire thing, would anything have stopped the uncle from going to the bank the next day and ripping up the deed?
I guess not.
Why not?
Well, because you said the owner or the uncle?
The uncle walks in, next day the bank's like, just kidding, I want him to take care of me. And he rips up the deed. Would there be anything wrong with that, other than being a jerk?
He still has the title.
Yes. So this is the important part to get. At the time when he handed him the deed and he handed the entire thing, the property didn't change hands, right? Kelsey, why did not the property change hands at that point?
Because he was still utilizing the property.
Yes. There was no present intent to give the property over. Did you do gifts in any class? You have a donative intent. Remember that? You need to have not only donative intent, but it has to be present. You have to have an intent that the transaction takes place immediately. It's obvious this wasn't the case here because he continued living on the land. Right? For all the nephew could have known, the very next day the uncle could have gone back and shredded up, ripped it up, and then he'd have nothing. This might be why you think of a life estate, by the way. We don't know this, but you never trust people, right? You never want to give some property up until you're actually dead and you can't use it anymore. Right? So, Zach, so was the conveyance valid? Okay, how come?
They
they said, because the key fact to them was that the property utilized in a way that I wouldn't show that title on the fact.
That's right. Okay, exactly. There was no present intent to give it. It was meant to be given later. Any gift that's supposed to take place after death must comply with the statute of wills. The statute requires 2 witnesses, right? Andrew, were there the 2 witnesses who signed it in this case? No. Andrew, why do you think it's important to have 2 independent witnesses sign a will, especially if someone's dead? What do you think that's an important reason? Right. Why? Why is it so important for independent witnesses to validate it? What happened here? The banker was dead. The uncle is dead. Who's the only person left? Is he a reliable witness? Oh, exactly. The problem when you're relying on an oral promise, when everyone else is dead, is that no one's going to tell if you're lying or not. And this is what happens in the concurring opinion, right? The concurring opinion says, wow, this testimony is really convenient, right? That how they did this entire thing where they transfer the paper, none of this may have ever happened, and we don't know. The reason why we have this issue of wills and this requirement to write down the promises is to ensure this stuff doesn't happen, so that if there's any doubt over whether this was valid, you bring the 2 witnesses to the court saying, oh, no, this is what actually happened. Okay? All right, questions? All right, so you need delivery, and the delivery must be for a present intent. It can't be for some attempt to be in the future. Okay, any other questions? All right, have a nice day. See you later. And please bring the roll up, whoever has it. Thank you.